Good morning, good afternoon, and good evening, everyone. Thank you for joining us in this joint webinar between Holland and Knight and Simmons concerning the SEC's new cybersecurity risk management strategy, governance, and incident disclosure rules. We are looking forward to an informative session on these important rules, and we're thankful that you guys are joining us here today. Nicole, if we get to the next slide. I'm Shardul Desai. I'm a partner at Holland and Knight in the Washington, D.C. office. My practice includes cyber and data security counseling, incident response, and white-collar and government investigations. I've advised numerous companies through complex cybersecurity issues and ransomware incidents, including the regulatory investigations that often follow and the data breach litigations that sometimes follow after that. In addition, I've advised several clients through SEC and DOJ security fraud investigations. Prior to joining Holland and Knight, I spent 9 years as a federal prosecutor in the Western District of Pennsylvania, where I was the office's computer hacking and intellectual property AUSA. In that role, I handled some of the DOJ's most significant cybercrime cases, including the Game Over Zeus and the Evil Core prosecutions. I also successfully tried several complex financial fraud cases. In addition to my prosecutorial experience, I have a background in computer science and physics, and I've worked as an operations research analyst where I conducted war game analysis for our military to assess technological gaps in our warfare strategy. I'm pleased to be here with you today, and let me turn it over to my colleague, Ira Rosner, to introduce himself.
Good day, everybody. Pleased to be with you and pleased that you can all join us. My background is not nearly as impressive as Shardul's, but I'm a partner in Holland and Knight's corporate and capital markets practice. I've been practicing securities law, capital markets, transactional matters, M&A, corporate governance, and regulatory compliance for public companies for the last 40 years, and frequently and regularly represent and counsel clients with respect to securities disclosure matters, including with respect to numerous emerging new rules, including the cybersecurity rules.
Robert, Emily, do you guys want to introduce yourself?
Sure. Hello, everyone. I'm Robert Allen. I am a partner in the UK London office of Simmons, and I lead our contentious data protection and privacy practice, which means that I advise clients, particularly in relation to litigation, disputes, complaints that arise as a result of data protection and other privacy contentious issues, also breach response, regulatory liaison, internal investigations, reputation management issues, and also class actions. And I advise clients across different sectors, but frequently in financial markets and asset management sectors.
Hello, everyone, and good morning from San Francisco. I'm Emily Jones. I'm a partner at Simmons. I head up our office here in the US. It's a representative office, so we're not advising on US law. Instead, our team here is supporting US companies as they move into new markets around the world, and helping them with their existing operations globally. And often that involves helping them to understand the data privacy and cybersecurity landscape, and that's the area that I specialize in as well. It's great to be here. Looking forward to this session.
Thank you, everyone. Nicole, if we go to the next slide. Ira, do you want to kick us off?
Sure, glad to, Shardul. Thank you. So I think most people are probably aware the new rules, new cybersecurity rules were adopted by the SEC in July of this year after a fairly lengthy gestation. In many respects, the rules represent somewhat of a codification of prior SEC guidance and policy with respect to cybersecurity matters. And in particular, over the last number of years, as cybersecurity has become a growing issue for everyone, the SEC has made a clear point to remind issuers that cybersecurity risk is something which requires disclosure in companies' financial and other SEC reports, particularly the risks and uncertainties resulting from cybersecurity, which is required to be discussed in management's discussion and analysis, which of course is intended in part to focus on trends and uncertainties that could materially affect an issuer. Of course, the new rules are relatively more granular than the prior SEC guidance, and now provide for an express reporting obligation for material incidents, which we'll get into in more detail. The new rules apply to both domestic and foreign private issuers in relatively the same requirements. There are a few minor differences, and we'll touch on those. Essentially, the rules cover two separate but related cybersecurity issues. The first is real-time reporting of material cybersecurity incidents, which sometimes we'll refer to as incident rules. And those requirements basically require issuers to report a material cybersecurity incident via Form 8K, or in the case of a foreign private issuer, on Form 6K. And then in addition to the incident rules, the new rules require detailed disclosures of cybersecurity risk management policies and procedures in annual reports on Form 10K and Forms 20F for foreign and private issuers, and we'll sometimes call these the governance rules. The incident rules become effective on December 18th, 2023, and so they are somewhat of more immediate concern to public companies. The governance rules disclosures are required in annual reports for fiscal years ending on or after December 15th of this year. So effectively, for any calendar year filers, the annual report for fiscal year 2023. Next slide, please. So as a quick overview, the domestic issuers must file a Form 8K under a new Item 105 to report a cybersecurity incident not more than 4 business days after the determination that the incident is material. This requires, of course, for issuers to have a process for materiality determinations, and the SEC has made it clear that materiality must be determined without unreasonable delay after discovery. And we'll get into what unreasonable delay means a little bit later in the presentation. For foreign private issuers, they must furnish a Form 6K to report a material cybersecurity incident that they disclose or otherwise publicize in a foreign jurisdiction to any stock exchange or to security holders. The Form 6K must be furnished promptly after the information in the report is made public, as described above. So effectively, the 6K reporting requirements have not really changed in terms of timing. The 6K obligation is triggered by reporting in the home market or to the home stock exchange or to security holders generally. It is not an independent reporting obligation under the rules for foreign private issuers. Next slide. Shardul, you want to take it from here?
Yeah, thank you, Ira. As Ira noted, the SEC cyber disclosure rules require public companies and foreign private issuers to disclose material cybersecurity incidents in the Form 8K or the Form 6K. And as Ira noted, that disclosure obligation is not new. The SEC has required disclosures of material cybersecurity instances and provided guidance on that effect back in 2011 and 2018. But what really prompted these rules was that the SEC viewed that these disclosures were inconsistent and not uniform. And so one of the main purposes of the SEC cybersecurity disclosure rules was to provide some standardization to these types of disclosures. And And so to understand essentially kind of what the SEC is looking for, the first step is understanding what their definitions are. The SEC defines a cybersecurity incident as an unauthorized occurrence or a series of related unauthorized occurrences on or conducted through a registrant's information system that jeopardizes the confidentiality, integrity, or availability of a registrant's information system or any information residing therein. From any of you that's familiar with data security practices, you'll notice that the common CIA triad is incorporated in these definitions, and that's confidentiality, integrity, and availability of information and information systems. The SEC also has made clear that they want companies to construe this definition broadly. It's preferable to be over-inclusive as opposed to being under-inclusive from the SEC's perspective. The SEC further defines information systems as electronic information resources owned or used by a registrant organized for the collection, processing, maintenance, use, sharing, dissemination, or disposition of a registrant's information to maintain or support a registrant's operations. A couple of key items that come from these two definitions, cybersecurity incident and information systems, that's incorporated in that definition is one, it relates to electronic information, doesn't relate to physical files. So we're talking about electronic information. The SEC has clarified that information systems should include both physical and virtual infrastructure. What this means is that your company's network IT systems, cloud-based environments, etc., would all be considered or be captured under this definition. Because the definition utilizes, or because the information system is focused on resources both owned and used by the registrant, it's clear, and the SEC makes that abundantly clear in its descriptions, that this applies to companies' third-party service providers. Thus, a ransomware attack on a ransomware attack on a third-party service provider could be a cybersecurity incident to a registrant. And so it's important to understand what's going on with your third-party service providers and getting information from them to see if that is indeed a cybersecurity incident. So overall, the focus is not on who owns the system, but the impact on the registrant.
Shardul, I think it's worth noting that the or used by aspect may create some interesting questions or uncertainties. For example, an issuer that provides electronic data regarding, let's say, its employees to a insurance company, and the insurance is for the insurance company's use in providing its insurance products to the employees. Is that use of that information and that information system by the issuer, or is that simply a transfer of information for a third party's use? So you may have incidents that affect a third party vendor that compromises information of the issuer or its employees, but isn't necessarily clearly within the definition of used by an information system. So you could have a situation where there is a material cybersecurity incident that doesn't literally fall within the reporting obligations of the new rules, but might be material enough to mandate reporting through some other auspices, such as press release or a item 801 Form 8K to report other material information. So that is something that issuers will need to be cognizant of.
Yeah, you make a great point, right? There's going to be some situations where, are we fitting round pegs into square holes here in fitting what matches the definitions that the SEC uses? We'll note that, the SEC does want everyone to construe these rules and these definitions broadly, But as Ira notes, there are going to be instances where what may seem obvious that falls under these rules, it may not actually fall under these definitions. The other part of the definitions that I wanted to talk a little bit about was under the cybersecurity incident, we talk about series of related unauthorized occurrences. It's not sufficient to simply look at a cybersecurity incident in isolation. The SEC wants you to consider whether a series of incidents are related in time or form. And so whether multiple actors are exploiting the same vulnerability, whether the same threat actors are periodically gaining access to some portion of data that in the aggregate is actually material. And so paying attention to both the occurrence, but also a series of occurrences is going to be important for companies as well. The SEC also references cybersecurity threats throughout the rule. We're not going to be focusing in on that too much, but the definition is available on the slide. Nicole, if we go to the next slide. So the cybersecurity disclosure rules require.
I appreciate it. You might want to get the AC guy.
The cybersecurity disclosure rules, but that reminds me, everyone, please put your microphones on mute as we proceed through this webinar. The cybersecurity disclosure rules require public companies to disclose material cybersecurity incident within 4 days upon making the determination of materiality. So it's important to understand that the triggering event is not the date of the cybersecurity incident or the discovery of the cybersecurity incident. And the SEC has said that it does not expect the determination in most cases to be immediate upon the date of discovery. What is the triggering event is when the company makes that determination that the incident is material. But one of the key factors here is the SEC wants to make sure that companies do not unnecessarily withhold making that determination. The term they use is this determination must be made without unreasonable delay. And the SEC did provide some identifiers as to what is unreasonable delay. If a company goes out of its way to modify its response protocol to extend the determination process of time to make that determination, that could be considered unreasonable delay. Also, waiting until all the information is known can be considered unreasonable delay. And so having a process in place to make that determination during the incident is going to be very important. Materiality is supposed to be the test for materiality to assess whether an incident is material is going to be following this long-standing securities law precedent, which we know from Basic v. Levinson. And that rule is whether there is a substantial likelihood that a reasonable shareholder would consider the information as important or as having significantly altered the total mix of information available. We've been advising companies to consider some of the following factors in making that assessment, but each company is going to have various different factors for its own considerations. Some of those factors may be the financial impact of the incident, the operational impact of the incident, reputational harm, legal and regulatory issues, and also the impact on business strategy. Obviously, theft of significant trade secrets may have a strategic impact on a company. The rule does provide, in very rare circumstances, it does provide a delay notification process. It requires the U.S. Attorney General to determine whether there's substantial national security or public safety risks in order to make that determination. We're not going to focus on this other than to note that it's going to be used only in the rarest of circumstances. Go to the next slide. So as I explained earlier, one of the purposes of these rules is standardization. And one of the things the SEC wanted to do was standardize what information is disclosed. The focus to the SEC is not the details of the incident itself, not the specific or technical information about the incident, but about the impact of material that's material to the company. And so what the SEC is looking for in item 5 of Form 8K is what's the material aspect of the nature, scope, and timing of the incident, and the material impact or reasonable likely material impact on the registrant, including its financial conditions and results of operations. As I mentioned earlier, some of the disclosures, we're not going to be able to wait till the end of the investigation where we have all information to necessarily make a disclosure. Where companies do not have all the information available but know that the incident is material, the SEC is going to require that companies file the 8K, and registrants may be required to file an amendment to its 8K once it has more complete information. As we've been advising companies about developing compliance programs in response to these new rules, one of the things that we've often looked at is the SEC's enforcement actions to date. Ira, do you want to discuss a little bit about the SEC's enforcement focus on internal disclosure controls, especially as it related to the First American Financial Corporation case?
Glad to. So I think, as probably anyone on the call is aware, the SEC has very specific rules regarding the requirements of public companies to maintain, in addition to internal controls over financial reporting, disclosure controls and procedures, sometimes called DCP. Essentially, these are controls and procedures which are intended to make sure that senior management is aware of developments within the company and is put in the position to evaluate whether any development is material and requires disclosure. Those rules sat around for a fairly long period of time. I believe they date back to Sarbanes-Oxley and have been kicking around in this current specific form for the past 20 years or so. And of course, issuers are not only required to maintain these controls and procedures, but they're also required to report on them and to aver whether in their public reports whether the disclosure controls and procedures are effective, at least at a reasonable assurance level. The SEC's in probably the last 5 years or so has realized that disclosure controls and procedures can be requirements can be a powerful enforcement tool, because it allows the SEC to bring enforcement actions against issuers that may have failed to make some form of disclosure without necessarily requiring the SEC to show that one of the anti-fraud rules was violated. And therefore, it frees the SEC from having to prove intentional behavior or even reckless behavior. In other words, the SEC doesn't need to demonstrate scienter in successfully bringing an enforcement action with respect to DCP. So as we mentioned, we've seen an increase in the last number of years in SEC enforcement actions that utilize failures of disclosure controls and procedures. I like to call it the Swiss Army knife of SEC enforcement, because it just can be used to cover a wide variety of issues and failures or alleged failures. I think we saw the very first SEC enforcement action based on DCP in the cybersecurity sector, involving First American Financial, which was an action that was announced in 2021. First American Financial was a fairly interesting situation. It was a vulnerability with respect to real estate transaction documents that First Financial maintained on a sharing application. First Financial business included title insurance and closing real estate transactions, escrow services. So it had a huge amount of data of consumers who were whose real estate transactions were being facilitated through First American Financial's application. The vulnerability exposed personal information on more than 800 million customer documents. So an enormous treasure trove of information, and included, of course, as you would imagine, fairly sensitive personal information. the situation sort of first developed when a financial journalist notified an investment relations executive at First Financial that the journalist was going to be publishing shortly an article regarding the vulnerability. This was the first the IR executive had heard of the issue, and the IR executive then reported that promptly to management. And indeed, and then shortly after which the article was published. Immediately following publication, within 1 day, First American Financial filed an 8K regarding the vulnerability and the cyber breach. Sounds all well and good, except it turned out that information security personnel from First Financial had known about the vulnerability for months prior to the journalist surfacing with the article. The security personnel failed to remedy the problem, and moreover, and probably the most critical fact to the SEC enforcement action, they failed to inform senior management of the vulnerability and the issues resulting therefrom. As a result, the SEC determined that, notwithstanding the fact that First American did make the disclosure when senior management did become aware of the situation, the SEC was brought an enforcement action based upon the failure of the disclosure controls and procedures that First American had in place to get the initial information regarding the vulnerability to senior management, and effectively did not place senior management in the position where it could evaluate the impact of the cybersecurity incident as well as its materiality. The enforcement action resulted in a civil penalty of nearly $500,000, as well as a cease and desist order. And this was, as we noted, the first, but certainly not the only enforcement action in the cyberspace that based upon DCP.
Thank you, Ira. Nicole, if you mind jumping ahead real quickly on the slides. So we're not going to speak about all the other relevant enforcement actions. We have them listed here. What I'll note is after First American Financial Corporation, we had Pearson and Blackbard that both had allegations of inadequate disclosure controls and procedures, as Ira talked about, but also allegations of materially misleading disclosures. So how those disclosures were communicated, the SEC determined that that disclosure was misleading. If we jump ahead to another slide. In addition, there is the recent activities in solar wind that has been of particular interest. In 2019, there was cyber attacks by foreign intelligence agents that breached SolarWind's network, injected malicious code in SolarWind software development programs, and that resulted in an update that allowed the criminals to have a backdoor into companies through that SolarWind program. The SEC, or at least SolarWind through 8K filings, had notified everyone that the SEC sent Wells notices to the company. And then this past summer, they provided another 8K indicating that the SEC sent Wells notices to current and former employees of the company, which included the CISO and the CFO. So this is a bit of a, well, let me explain what a Wells notice is. That's a formal letter indicating that the SEC investigators are recommending an enforcement action. So with SolarWind, what we're seeing is an escalation by the SEC to not focus just solely on the company, but including management level responsibilities, which plays into the next part of these rules, which is the governance side, or the governance rules that disclosures that we'll be talking about. If we go to the next slide. With that information, we've been providing some practical considerations to companies on how to address and comply with these cybersecurity incident disclosure obligations. in the interest of time, we're not going to go through each and every one of these bullets. But what I do want to just emphasize a few key items here. One is it's important to establish criteria to escalate relevant cybersecurity risks and incidents, not just incidents, but also the risks, up through to incident response teams, to senior management, and to the board of directors. Companies should also reassess their vendor management programs to include cybersecurity incident response reporting obligations, and as we'll see with the governance side, also to ensure that the companies have strong cybersecurity programs. We have also, in order to ensure that there's no unreasonable delay in making a materiality determination, we've also been recommending companies consider developing a materiality assessment team, which is a multidisciplinary team that includes members of your incident response team and others necessary personnel who can help make a determination on materiality. And once the incident reaches the incident response team should have some criteria as to when to call the materiality assessment team to make a call for them to be assessing the situation. And that team should meet promptly to make an assessment and then meet thereafter periodically throughout the incident and on an as-needed basis, for both periodically and as needed.
Shardul, I think it's useful to pause on this for just a quick second. Many issuers already have disclosure committees, and certainly the issuers can make use of existing disclosure committees and structures, potentially with some additional personnel that are particularly relevant to cybersecurity incidents as a basis for their materiality assessment team. But I think what's really critical to note is and one of the things we've been advising our clients about, probably top of mind, is protocols within the incident response plan to make sure that senior disclosure decision makers are being brought into the circle of knowledge regarding a cybersecurity incident very early on, so that those people are aware of the situation and can make an initial evaluation as to its importance, its materiality, and make sure that all of those people within the company needed to make an appropriate materiality assessment, including the materiality assessment team, are involved at an early stage. I think particularly in light of some of the enforcement actions that we've described on this call, and particularly the SEC requirement to determine materiality without undue delay, that is probably one of the key considerations that needs to be accounted for in the cyber incident response plan.
Absolutely. I think that's very important to make sure that the key decision makers are brought in. And that's, as we talked a little bit about the enforcement actions, that's one of the biggest issues, is that the key decision makers aren't brought in early enough. The other thing that companies should just consider is, once you make a materiality determination, the 8K filing may be the first public filing about the incident that's going to happen. And so there needs to be a communication strategy to think about the various stakeholders, employees, customers that may also need to be notified. Also, there should be a communication strategy to ensure that all communications related to the incident is consistent, that your notification letters, your 8K, your media disclosures, that they're all going to be consistent throughout the process. With that, I think I'm going to turn it over to you about the governance disclosures.
Thank you, Shardul. And I see that the clock is running pretty fast, so we'll try and make this as quick as we can and as painless as possible. So as noted before, the second half of the new SEC rules involves governance disclosures regarding cybersecurity, risk management, and governance. For these rules will first kick in with 10Ks that are being filed in 2024. Although many issuers have already given prior SEC guidance, many issuers are already including information about cyber risk management and governance because of pre-existing requirements to discuss risk management generally, and how the board of directors deals with enterprise risk management. These rules are an extension of that and a particularization, as Shardul mentioned, in part to achieve a little bit more uniformity in disclosure and standardization. Items 106B of SK, and there is a parallel set of rules in item 16B of Form 20F for foreign private issuers, requires disclosures of cybersecurity risk management and strategy. And these descriptions, the SEC provides generally to cover processes for assessing, identifying, and managing material risks from cyber threats. And then the SEC breaks it down a little bit further to require descriptions of whether and how cybersecurity processes are integrated into the overall ERP system or process, whether third-party providers are used to assist in that, and whether processes exist to oversee and identify material risk associated with third-party providers. So going back to the key third-party provider issues that we've discussed earlier, particularly for companies that have moved from in-house cybersecurity systems to putting their information on the cloud, including companies that take a hybrid approach. In addition, the new rules require disclosure of whether any cybersecurity risks, including previous cybersecurity incidents, have materially affected or reasonably likely to materially affect the registrant. So this is somewhat of a backward-looking disclosure requirement regarding past risks, as well as a forward-looking requirement to discuss risks that might materially affect or reasonably likely to materially affect the registrant. Next slide, please. SK new item 106C, and again 16C in Form 20F, now requires specific disclosures of board and management's roles in managing cybersecurity risk. And that includes descriptions of the board's oversight of cybersecurity risk, identification of board committees or subcommittees, and the processes by which the board or any subcommittee is informed about cybersecurity risk. So essentially, I think requiring an insight on the disclosure controls and procedures that the company has adopted to make sure that the board is appropriately informed. And then there's a secondary category of governance disclosures regarding management's responsibility, so below the board level. And again, management's role in assessing cybersecurity risks. And then where it gets a little granular are the management positions or committees that are responsible for assessing and managing these risks, and the relevant expertise of those members of management that are involved in that. In addition, disclosure is required for processes by which, again, persons are informed about and monitor the cybersecurity risks. Again, a DCP view. And then the last item is whether these persons, members of management, report information to the board or committees of the board. So again, it's probably a little bit repetitive of the prior board disclosures, but it looks like what the SEC is really focusing on here is the process and the procedures that companies are using to deal with cybersecurity risk. Next slide, please. So a few notes about the drafting of these, and the SEC has been somewhat helpful because there were a lot of, extensive amount of commentary, that was raised in response to the proposed rules that did cause the SEC to provide a little bit of assistance here. So explicitly within the rules of this, the disclosures have to be in sufficient detail for a reasonable investor to understand the cybersecurity risk processes. Obviously, this is something that's going to vary from issuer to issuer, because it's really going to depend on the issuers, the criticality of cyber systems to the issuer, and the nature of its business. So, for example, one might expect that a company that is consumer facing, that has, for example, extensive amounts of credit card information, or other personal information of millions and millions of consumers, is going to have different vulnerabilities and as compared to or contrasted with a company that's perhaps a business to business model that has relatively few customers, and where the customers the customers' data is of a variety that isn't subject to cybersecurity breaches as a consumer-facing business. So there'll be some variability there, and I think that it's going to be important for issuers to avoid a one-size-fits-all approach, or simply cookie-cutter disclosures that they're stealing from other issuers. I think that they will need to be relatively specific and particularized to the issuer's particular business.
If you mind, I don't apologize. I'm going to jump in here real quick. There's a couple other slides that we have on governance, is going through kind of these rules about the disclosures, as well as the NIST cybersecurity framework was modified with a 2.0 version as a draft version on governance, and some other board oversight cybersecurity risk disclosure considerations. But in the interest of making sure we provide our colleagues at Simmons and Simmons some time to discuss their unique aspects as this plays out especially on the incident disclosure rules, as that plays out in Europe, I wanted to make sure we turn it over to Robert and Emily at this time, if that's okay.
That's okay, but I'll just make one point that I think is worth making here, and that the SEC has been very clear that they don't expect issuers to provide a roadmap for the criminals, and so they expect issuers will still steer clear of security sensitive details and keep things at a level that should intended to avoid providing a roadmap for further harm. And with that, I'll yield.
Robert?
Thanks, Shardul. Thanks, Ira. Nicole, if we could go to the first slide in the Simmons section, please. There we go. Well, the rules set by the SEC that Shardul and Ira have just outlined are certainly the most prescriptive market disclosure rules in relation to cyber attacks I'm aware of by some margin. For foreign private issuers also listed in the UK and other UK listed companies, the requirements in that market are not up to this level. In the UK, the Financial Conduct Authority hasn't yet suggested a move to what the SEC is doing, and the position remains as it was before in respect of disclosures concerning inside information. And that's essentially down to the application of the Europe-wide market abuse regulation, which has been implemented by various rules, and in the UK is really contained within mainly the disclosure and transparency rules. And they contain an obligation on listed companies to disclose information to the market that would be likely to have a significant effect on the prices of financial instruments. And that's a regulatory definition of inside information in the UK, with the word significant playing the role of the SEC's material. Specific hours or days time frame isn't indicated, so none of your 4 days or anything like that, but legislation mandates that the public information should be made as soon as possible. And in relation to this, the disclosure and transparency rules say that if an issuer is faced with an unexpected and significant event, as to which a cyber attack must qualify, a short delay might be acceptable if it's necessary to clarify the situation. And in addition to this, an issuer is able to delay disclosure of inside information where immediate disclosure would prejudice legitimate interest of the issuer. Delay would not be likely to mislead the public, and the issuer is able to ensure the confidentiality of such information. Now, it's possible to see how a scenario justifying that kind of delay might arise immediately following a cyber attack, although there may always remain a question over the issuer's ability to ensure the confidentiality of information, given the ability of the malicious actor to reveal information about a cyber attack, and assuming it's exfiltrated or has access to data, disseminate it further. So one quick example, the large outsourcing company Capita, listed on the London Stock Exchange, was hit by a major cyber attack earlier this year. Its first disclosure to the market stated that the attack occurred on Friday, the 31st of March, 2023. Its regulatory announcement was released on Monday, the 3rd of April, so just the following working day. However, compared with the information that SEC filings may require, the information provided in the statement really was minimal. It said there was a cyber incident. It primarily impacted access to internal Microsoft Office 365 applications, disrupted some but not most services, and that the incident was successfully isolated and contained. The announcement also said that there was no evidence of customer, supplier, or colleague data having been compromised, and that turned out to be to quite some extent not the case. But as we'll come on to hear now from Emily, that disclosure to the market may have been driven by the much more specific and obligatory reporting European and UK regime set out in relation to privacy and data protection, which obviously runs alongside. Emily.
Before we jump over to Emily, Nicole, do you want to give the CLE confirmation information or the code so everyone has it, and then we'll...
Yes. So for everyone that hasn't already noticed, I included the request form, the link for the program, in the group chat, and now I will provide the affirmation code. That is HK23 1026 7445. So again, that is HK23 1026 7445, and I will now include this in the group chat as well.
Yeah, thanks, Nicole. So if you wouldn't also mind just moving to the next slide. So one of the really interesting things about the new SEC disclosure rules is the interplay with existing laws that we have covering a specific category of information and specific category of cyber breach under the EU and UK GDPR. So obviously we've talked a lot about and Shardul and Ira have talked a bit about thinking about the impact of an incident on obviously on investors and so forth, but the real focus of GDPR is in relation to data relating to individuals. So to the extent that any incident comes within the scope of that definition, and the company involved is caught by the UK GDPR or EU GDPR, then it's really critical to think about whether a notification is needed. And there's two types of notifications that are required depending on the severity of the breach. And again, this goes to the importance of a very quick assessment of a company in terms of to decide whether determine whether this is a notifiable breach. So I'd say there are definitely parallels in terms of the breadth of definition of breach, but where we have a mismatch here, and there's a really interesting interplay, is between the sort of the notification thresholds. So there's, as I said, two types of notification, one to regulators and then potentially to individuals. And so I'll start with the regulatory, the notification to regulators. And the reason why companies need to think carefully about this is because once a notification a disclosure has been made under the new SEC rules, that's obviously could be read by and could be noticed by one of the either UK or other EU regulators, and so they're going to potentially be thinking about, should we be hearing from that company in relation to the to their obligations under the GDPR. So if a data controller, so that's the entity that decides what data is being collected and how it's being used, so the company impacted by the breach often is aware, once they become aware, or they know they think there's been some kind of incident, their decision needs to be made then as to whether a notification should be made, and that has to happen within as soon as possible, or without undue delay is the terminology, or within 72 hours. So we're seeing a mismatch there in the timing. And if there is any kind of delay, then that has to be explained. And obviously we know that these incidents are very complex, and so that's quite likely, but companies need to provide information about why that is the case. You would only, if the threshold is you have to notify unless there's unlikely to be a risk to the risks and freedoms of individuals. So it's a pretty low threshold, and so more often than not, companies would tend to notify. And that notification has to be accompanied by a whole range of information, very similar, I think, to the SEC requirements in terms of the scope of breach, what's happened, consequences, and mitigations. And what's really important too is the sort of documentary piece of this, so keeping records, understanding why decisions were made to notify, what steps have been taken, and so on and so forth. And then moving on to the next slide, the other notification angle here is to individuals, data subjects. We've just got a small typo on the top line there. So data subjects, those are the individuals. That's the terminology under GDPR. So if the breach is likely to result in a high risk of adverse effects on those individuals, then they also need to be informed. And at this point, obviously, the breach is going to become public. That again, this is where it's important to have a really consistent approach in terms of dealing with regulators in all of the affected jurisdictions, US, EU, wherever that might be, UK, and so forth. And controls of that data have to tell individuals without undue delay. So that's it, shortening the timing even more. That would, if you have a company's identified an incident and actually been able to implement measures to prevent a high risk or minimize or mitigate, so that that there was no longer a high risk to individuals, that would mean that a notification to individuals would not be required. But again, companies would need to think very carefully about whether that is the case or not. Again, documenting why decisions have been made, steps have been taken, and so on and so forth. And again, it really highlights some of the considerations that Shardul mentioned around having the importance of preparation, having a team, having a plan, knowing what to do if an incident arises. So I'll hand back to Rob to talk a bit about vendors and the supply chain as well.
Yeah, thanks, Emily. Just on the next slide, I'll treat this pretty quickly. It might be tempting for non-US companies who are not foreign private issuers to ignore the new rules. However, there will be a number of cyber incident scenarios where it will be important to consider the effect of the rules, even if you as a company aren't obliged to make the relevant filing. So if you're a vendor and the attack affects you directly, you might be processing data for companies that are regulated by the SEC, or a group company similarly regulated might become affected by the attack on you. As Shardul has explained, a ransomware attack on a third-party service provider may constitute a cybersecurity incident for the regulated company. Even if you're not formally processing data for a regulated company as a supplier, you will still have interfaces, data sharing arrangements with the regulated company, and that could quickly mean that the entity is impacted by the cyber attack on you, or at least there's a realistic possibility that it might be, and that you might be under contractual obligations to make certain information available to that entity entity, as well as cooperate with it in its own effects to mitigate the impact from the attack and remediation. So vendor contracts will be scrutinized, access rights, indemnities, cooperation clauses, and so on. Also, there could be another third party within the supply chain that's subject to an incident. And again, the regulated entity may have to file the regulatory disclosures that, depending on your position in the supply chain, may also have an effect on you. And in all the circumstances, the risk is increased significantly if you're named at some point. So as Emily said, proactive consideration of the new rules should be assessed for inclusion into your incident management plan. Work out whether there are scenarios where you may be impacted by a filing, and used as also a consideration in basic incident response and its testing. It'll be valuable to look at tensions that might arise because of the misalignment between the obligations imposed by the various regulatory regimes, particularly in terms of content and timing of mandated disclosures. Investigations, both regulatory and internal, invariably will flow from cyber incidents. Obligatory public filings will invariably increase litigation risk. As to these aspects, investigations in particular, data transfer rules between the US and Europe may come into play. And I don't know how much time you have, Emily, but you might want to just touch on those data transfer rules finally.
Yeah, thanks, Rob. So just moving on to the last slide. So a final point that we wanted to flag. So in addition to thinking about whether there's notification requirements under GDPR, once an incident has occurred, and perhaps during the investigation of that incident or further questions that perhaps the SEC may ask, there may very well be a transfer of data from the UK or EU to the US, and once that is once there's a prospect of that, companies need to think about compliance with the transfer provisions under GDPR, which require a legal mechanism to be in place to legitimize the transfer. And so careful consideration is really needed, depending on what the data flow looks like, who's the exporter of the data, who's the importer in the US. Is there a mechanism in place to enable that transfer? And there has been, and I think very helpfully, a letter published by the UK regulator, the ICO, saying that one of the derogations in the could be used for transfers to the SEC because it's in the public interest. But again, this really does need some assessment on a very case by case basis and documentation, as I said. And finally, any processing activity, including transfers of data, will need to comply with all the other GDPR principles and obligations, such as transparency, minimization of data, and so on and so forth. So, in summary, there's quite a lot to think about, not just at the sort of start of or initial awareness of an incident, but then, of course, as investigations and so on continue. So perhaps I'll hand it over to Shardul to wrap things up.
Thank you, Emily. Yeah, we have one question that came in, and it's, if my public company is running most of my infrastructure on a cloud and the cloud company is breached, what does the cloud company have to disclose, if anything, or is it all on the public company to disclose the incident? And it kind of goes to some of the vendor issues that we've been talking about that all of us have mentioned. If the public cloud company is a registrant, it's a public company itself or a FPI, it's likely that since this impacted its information security system, the cloud environment that it runs, it's likely that this is going to require notification by the public cloud company if it's deemed material. As it goes to the public company, it is a third-party breach, but if it impacts the company such that it's a material incident to that company, it's likely to require disclosure as well from the public company in that instant.
Yeah, Shardul, I think it's important to stress something that Rob touched on briefly with respect to multinationals or international issues, and that is particularly just for U.S. only issuers that it's going to be increasingly important for cyber vendor contracts, cyber-related vendor contracts to include specific language regarding the obligation of the third-party vendor to inform the customer, that is the public company, with respect to cybersecurity breaches that might affect the public company customer. Provisions that provide for cooperation with respect to disclosure and clear understandings that a public company that's subject to the SEC's reporting obligations has to have the ability freely to comply with those reporting obligations, notwithstanding, for example, provisions of confidentiality that might otherwise be in those sorts of contracts, and probably will be a vice versa aspect to that as well. And I think it'll be important for these contracts to provide representations regarding the vendor's cybersecurity measures and protocols, and its ability to protect the public company's information and critical data. So, given the focus of the rules on third-party vendors, these sorts of operational contractual issues will become more and more prominent.
Absolutely. Great insight there, Ira. I think, as you guys can all see, there's a lot to talk about on this subject, and a lot of ground to cover. We weren't able to really dig into the governance considerations as much as we would liked. But with that, please feel free to contact any of the speakers here today if you have any questions or anything to follow up. With that, our webinar is at a conclusion, and we want to thank you all for joining us today. Thank you.
Take care.